Dear learners, we shall be starting with the lecture on formalities of contract of sale. In this lecture, we shall be looking at how a contract is made, what are the various modes of making a contract of sale of goods, how the price has to be determined, so on and so forth. This topic, formalities relating to the contract of sale, I have divided into two parts. Some of the ingredients I'll be looking at in part 1 lecture and some in the lecture which is to immediately follow this part 1 lecture, that is part 2. So beginning with our discussion, we will first try to answer a contract of sale, how is it made? Now, there is a provision, Section 5 of the Sale of Goods Act, which provides as follows. A contract of sale is made by an offer to buy or sell the goods for a price and acceptance of such offer. So, it may be initiated from the level of the buyer or the seller, and the other party may accept it. The contract may provide for the immediate delivery of the goods or immediate payment of the price or both, that is immediate delivery as well as immediate payment, or for the delivery or payment by installments, or that the delivery or payment or both shall be postponed. So for your benefit, I have highlighted some keywords here. First is the offer, second is the acceptance, which is a basic of all contracts, no less than a contract of sale of goods. However, there can be various ways in which the buyer and the seller may perform their part of the promise. So for example, there can be an immediate delivery of the goods along with an immediate payment of the price. So if you go to a vegetable vendor, for example, if you buy vegetables, so you immediately make the payment and you immediately get the goods. So both the parties are performing their obligations under the contract very simultaneously in close proximity. However, it is possible that the delivery of the goods may be immediate and the price may be paid later on. Or there could be delivery of the goods in installments, for example. So, if let's say that I order 50 different computers from a proprietor, so he may agree that I am going to provide 50 computers in 10 installments each. So 10 consignments in every installment, in which case the delivery is by installments. Now the payment could also be corresponding to the installments, in which case the payment would also become through installments. Like if you buy a motorcycle or a car, and if you buy it on credit, so you can pay the installments monthly, or their delivery or the payment both could be postponed, that is at a future date. So based on this section 5, we can break down various steps of a contract. There is an offer from any of the parties accompanied by an acceptance from the other party, followed by the delivery of goods by the seller, followed by the payment of price by the buyer. So the first part of section 5 delineates these steps in a contract. Apart from that, subsection 2 of section 5 also provides as to what are the various ways or modes in which a contract could be made. So it provides that subject to the provisions of any law for the time being in force, Ordinarily, a contract of sale may be made in writing or by word of mouth, or partly in writing and partly by word of mouth, or may be implied from the conduct of the parties. Now, to break down this section 5 clause 2 for your benefit, so we can break it down into various modes. So a contract of sale, it may be purely in writing, it can be purely oral, that is by words of mouth, it could be a hybrid between partly in writing and partly oral, and lastly it, it arises neither from the words that are spoken by the parties nor through any written agreement, but has to be implied from the conduct or action of the parties. Now we shall be looking at how a contract can be made through each of these modes. So writing, this is a very simple and straightforward way of entering into a contract of sale. The benefit of reducing the contract in writing is that all the rights, obligations, liabilities of the buyer as well as the seller, they are predefined as well as clearly laid out. So there is no scope that is left for dispute between the parties. So the best thing or the most efficient way of performing a contract is through writing, because both the parties know clearly in writing as to what is expected from them and what is it that they expect from others. So dispute resolution in written contracts is easier, as well as it avoids the probabilities and chances of dispute being arisen. Second, an oral contract. Now, oral contract, as the name suggests, is by words which are spoken by mouth. So, for example, if you go and purchase fruits or vegetables from an open market, so what you must have experienced is that you do not give a written order to the vegetable or a fruit vendor. In the same way, many of these vendors, they also do not give us any receipts. So there is nothing in writing. But how much of vegetables we want, what kind of vegetables we want, everything is spoken. So this is a kind of an oral contract of sale of goods. In the same way, use of any local transport such as e-rickshaw. This is also an oral contract, because you merely inform by words of mouth your destination to the driver of the e-rickshaw. He also informs you how much payment he expects from you. So here again, nothing is broken down into writing. So this is also an example of an oral contract. The next mode is a contract being partly in writing and partly oral. So if you take an example of the receipt which is being shown here, so there is the date of the transport, the number of the car, the place from where the transportation shall begin, the destination where the transportation shall end, the total fare, and the signature. But there are certain other aspects of a contract of travel or conveyance. So for example, this receipt does not provide as to what is the time of pickup. In the same way, it also does not provide information about the number of persons and what is going to be the fare per kilometer. Although the total fare is provided in the receipt, but it does not provide what is going to be the unit price. So here, if you orally tell the taxi vendor what is going to be the time of your pickup, how many persons are there, and what is going to be the unit price of fare per kilometer, then there are certain aspects that have been included in the contract and intimated to a party merely by words of mouth. And then there are certain aspects which have been written down in the receipt, which is a kind of an agreement. So this would be an example of a contract which is partly writing and partly oral. Now, if we just transmutate this example to a sale of goods. So for example, if you go and buy a book. So when you go and buy a book, obviously the book has a title, the book has an author, the book has an ISBN number. So there are certain things which are written into the book. But then there might be certain other aspects. For example, when the book has to be picked up, on what date you want the delivery of the book, so on and so forth. So there are certain aspects of this contract of sale of a book which have been put into writing as evident from the book or the receipt, and there are certain things which have to be communicated orally. So it has elements of both a written contract as well as an oral contract. So insofar as dispute resolution in this kind or mode of a contract is concerned, it usually arises on those issues which are in oral form, because it becomes easier for the parties to renege or to go back on what they have said, or perhaps they might not remember what was communicated to the other party. If it is in writing, then it cannot be disputed by the other party. So the chances of dispute here, they are less as compared to a purely oral contract, but more as compared to a contract which is purely in written form. Now, if there is any contradiction between what is claimed to have been said and what is in writing, it is what is provided in writing which is going to prevail. The next is a contract which is through the conduct of the parties, or rather it is implied from the conduct of the parties. So implied means it is not express. And what it means it is not express? It means that this is something that has to be gathered from the construction of the contract and intention of the parties. So this is a kind of a contract by the actions of the parties which is presumed to have been the consent of both the parties. So it is neither in the form of words which are spoken nor through a written agreement. So as you can see the picture, we have a kiosk store. Now obviously there is somebody who must have installed the kiosk store, but when you are alone at a kiosk store, so obviously you've not entered into any written contract with somebody who's the owner of the kiosk store, because this is self-operated. In the same way, you are interacting with a machine through the instructions. So you also do not say anything to the machines. So it cannot be said that it is oral. But what you do is that you simply operate on a computer, make the payment, and the goods, they come out in a tray. So this is a contract which happens neither through spoken words nor through any written agreement, but merely by the conduct of the parties. The conduct is of putting the money in and the goods coming out. In the same way, in our everyday examples, we find many contracts of sale of goods which are through conduct of the parties. Just to give you one example, if you happen to go to a eatery or a restaurant, so from my own personal experience, one of the first thing that a waiter or somebody who's serving, they do is that they bring a water bottle and keep it on the table. Now they do not ask you whether you require the water or not, and it is also possible that you do not ask for a water bottle. So without any words being spoken, he just places a water bottle on your table, presuming that you would be requiring it. Now supposing you did not ask for the water, but it was kept on the table. So you open the water bottle and you consume the water. Now there is nothing that has been said, there is nothing that is in written form, but your action or conduct of opening the water bottle, consuming the water, is an implied contract that you have accepted the goods. In the same way, the action of the service provider or the seller is that he has kept the bottle. So it is like an offer to you. So when you open the bottle, as soon as you unseal the bottle, it is like you have accepted the offer which was made through a conduct. So this is like acceptance through a conduct. So this is also an example of a contract of sale of goods through the conduct of the parties. In the same way, if you travel by any local transport or a local bus, so what you do is that you enter the bus, you make the payment to the conductor, the bus stops, and you exit the bus. So it is possible that no words are spoken, there is no written agreement that is exchanged. So you have performed the conduct by entering into the bus, making the payment. The service provider performs the conduct of driving the bus as well as providing you with the services of taking you to the destination. So this is also an example of contract through the conduct of the part. Now we will look at the law where the goods have perished before the contract as provided under section 7. So what section 7 provides is where there is a contract for the sale of specific goods. So we know already what is specific goods. The contract becomes void if the goods without the knowledge of the seller have at the time when the contract was made perished or become so damaged as no longer to answer to their description in the contract. So you can read this rather long provision. Then based on this provision, we'll do an exercise in order to better help you understand this provision. So the exercise is that there is a contract between a buyer and a seller, that is X and Y respectively, for sale of consignment of textiles to arrive by ship. However, unknown to the seller, that is Y, the goods had, before the contract was made, when lying at the port of loading, they were destroyed by a sudden flood. Now the question is that whether X, who is the buyer, is entitled to sue Y for the breach of the contract. So a contract was already in place, but before the contract could be performed, without the knowledge of the seller, the goods had perished or been destroyed. Now what you're required to do is that you read section 7 as provided on the left hand side. So the essentials it provides is without the knowledge. So here we have the words unknown, the knowledge of the seller. So here unknown to Y. The goods, they become damaged. So here the goods have been destroyed. So here there is a kind of no knowledge or no fault of the seller. So in this case, the case of X, that is the buyer, against Y, that is the seller, will not succeed because the seller will be granted protection under section 7 of the Sale of Goods Act. Now this section 7 of the Sale of Goods Act is premised upon a provision of the Indian Contract Act, which is general in nature, that is section 20. According to section 20, agreement is void where both parties are under mistake as to matter of fact. Where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement is void. So here both the parties were unknown that the goods have been destroyed at the port of loading. So there is a mistake as to the matter of fact regarding the existence of the goods. So Section 7 of the Sale of Goods Act corresponds to Section 20 of the Indian Contract Act. Now let us take another exercise. So there is a contract of sale of 500 books titled Commentary on the Law of Sale of Goods by John N. Adams. So we have the title of the book and we have the name of the author of the book. The consignment was lying in the bookstore in 5 cartons of 100 each. Unknown to the seller before the sale, 1 carton was stolen. Now, can the buyer be compelled to buy the remainder of the 4 cartons? So here the original contract was for goods which were of this description. Total 100 in 5 cartons. However, what was being provided was 4 cartons which contain, let's say, 80 books. So this was a kind of a novation or an amendment to the original contract without the consent of the buyer. So in this case, the buyer cannot be compelled to buy the remainder of the 4 cartons. Now, this law is applicable in those situations where the goods have been destroyed by any flood or calamity or for any other reason, or they have been stolen. Only part of the goods have been destroyed or stolen and some part remain. So the question is that whether the seller can compel the buyer to buy the remainder of the goods. The answer is no, because this is a kind of a modification or a novation to the original contract. Only the original contract can be enforced. However, it is open to the buyer, if he so feels like, to buy the remainder of the goods, but he cannot be compelled to do the same. Now we take up another provision relating to the goods perishing. However, it is before the actual sale but after an agreement to sell. Now, what is the difference between sale and an agreement to sell? The legal consequences, it is discussed in a separate lecture which is titled as Difference of Sale with Allied Concepts such as agreement to sell, barter, contract of sale and labor, contract of work and labor, so on and so forth. But let us here examine what is Section 8. So it reads as, where there is an agreement to sell specific goods and subsequently the goods without any fault on the part of the seller or the buyer perish or become so damaged as no longer to answer their description in the agreement before the risk passes to the buyer or before the goods have been transferred, the agreement is thereby avoided for both the parties. Now let us do a case on this. There is a contract for the sale of a horse on the condition that the buyer should have it for 8 days for trial and be at liberty to return it at the expiration of that period if he did not find it suitable for his purpose. The horse, in the meantime, while it was in trial, it died without any fault on the part of either party 3 days after it had been delivered to the buyer. So the question here is, can the buyer sue the seller, or can the seller sue the buyer? So the answer to this case here would be no. No party can enforce the obligations of the other party because in such kind of a situation the contract has been avoided. So what is required here is that there is an agreement to sell specific goods. So we have a horse who is agreed upon, specific. There should not be any fault on the part of either of the parties. So here the horse has died without any fault on the part of either of the parties, and the risk has not passed, meaning thereby the horse has not become the property or under the ownership of the buyer. He only has possession of it, so he can return the possession after a period of 8 days. So here the benefit of Section 8 would be accorded to both the parties. So to break down this section 8 for your benefit, there is an agreement to sell. In the example, it was a horse. The goods have perished. In our example, the horse died without any fault of either of the party and before the sale was expected to happen. So before agreement to sale and the sale actually happening, the goods become perished or destroyed without any fault of any of the parties. So if these situations are fulfilled, the contract is thereby avoided and both the parties are absolved from performing their part of the promise. So with this, we come towards the closure of this part 1 on the formalities of contract of sale of goods. We shall be continuing with this discussion in the subsequent part 2 lecture. Thank you.